So by sneaking polygamy into civil marriages, we feel that Uganda is creating a standard where the standard for marriages in Uganda is going to be polygamy, and women will have no choice but to always endure polygamous relationships. And yet we are moving towards a human rights, value-based system. So we feel that this is going to violate women's rights, and this is something that shouldn't be allowed. Also, when we read this marriage bill, we realize that polygamy and its interpretation is actually only polygyny. This law doesn't allow for polyandry, which is advancing unequal rights for men and women. What I mean by this is that it only allows men to marry multiple spouses, but it doesn't allow women to marry multiple spouses. The spirit of Article 31 is that marriage should be equal. Equal rights within marriage, during marriage, and upon dissolution. So if men are allowed the particular entitlement in marriage, we believe that even women should be allowed to equally marry more than one spouse.
You see, sorry to interrupt. You see those mamas you're getting, the Honorable Fox Odoye arrived.
Yes.
And he has been a very strong advocate of...
Once again, my name is Rose Wachkona, and I'm going to present our position on the marriage bill. First of all, we want to congratulate the Parliament of Uganda for reintroducing the marriage bill for another time, yet again. This is something that we've been fighting for over 60 years as the women of Uganda, as we try to advance marriage equality. So we look forward to a bill that is going to not oppress women, not to exploit them and abuse them, but a bill that is actually going to liberate them and advance marriage equality. To start with, we wanted to say that marriage is grounded under Article 31 of the Constitution, which allows for the rights of the family, and under it, we see that people have a right to marry and found a family. They have equal rights in marriage, during the marriage, and upon the dissolution of the marriage. They have parental rights that are equal between the spouses. They have succession rights, and they also have individualized free consent to enter and exit the marriage. We also have the protection of children, which is handled under different acts. So we are hoping that the spirit of the bill is going to be in line with Article 31 of the Constitution to advance the rights of all. The fight for marriage laws started in 1964. I think this is something that the committee is aware of, with the Commission on Marriage, Divorce and the Status of Women, where a report was made to try and advance women's rights, but it was ignored. Subsequently, in 2003, this discussion was resurrected when we had the Domestic Relations Bill. This bill in itself was very progressive. It advanced the criminalization of the refund of bride price. It advanced conditions for people to enter polygyny. It also criminalized widow inheritance, and also advanced property rights for women who are not just married, but also those who are in cohabiting relationships. It also rejected sex, allowed for the rejection of sex for women on health grounds. This particular bill was opposed and subsequently abandoned by that parliament at the time. In 2009, we had new bills that were introduced. We had the Marriage and Divorce Bill and also the Administration of Muslim Personal Law Bill. Once again, this law was opposed and also put on the back burners. 60 years down the road, we are still having this same conversation. And we, as the women's rights movement, we haven't changed our position in our asks towards our parliamentarians. We have spent the last 60 years seeking a law that guarantees marriage equality and not a law that perpetuates marriage as an institution for the exploitation, subordination, and oppression of women. We hope that the marriage bill will do this for us as the women of Uganda. To give it a bit of context, I want us to note that marriage is procured publicly. We have public marriage ceremonies where people come and celebrate a couple coming together. But most of marriage is unfortunately performed privately. And it's in private where women suffer the most abuse, including domestic violence. And it's in the private also where the law hesitates to actually enter, regulate, and legislate upon.
Dear Ugandans, the Electoral Commission is conducting an update exercise of the National Voters Register and registers for special interest groups. The exercise will take place at each parish countrywide for 20 days from 20th January to 10th February 2025, daily from 8 a.m. to 6 p.m., including weekends and public holidays. The update exercise is intended to include particulars of eligible voters that are not on the National Voters Register. During the exercise, the following actions will be done: registration of newly eligible applicants, transfer particulars for voters who wish to transfer to new voting locations, correction of misspelled particulars, inclusion of omitted particulars, voters' claims omitted from the register will be handled. Students who were registered by NERA and have since turned 18 years of age need to present their particulars for updating and assignment to polling stations. Voters are therefore urged to check and confirm their polling stations to avoid any inconveniences on polling day. This message is from the Electoral Commission.
Honorable Member, what I am presenting is contained in this.
Okay.
So are you making a summary of it?
Yes, I am making a summary. I'm not reading it,
We
but
should be using which one? There is the analysis of the Marriage Bill 2024 from women's rights organizations and activists. Is it the one you are?
yes, that is it.
So we follow you on this, or we go to this one?
It is the same thing.
It's the same thing.
Yes, those are just photocopies of it.
Okay.
Yes. I'm just summarizing it so that we don't waste a lot of time.
So the main content summary.
Yes.
Honorable colleagues, I think you're comfortable with that. Okay, let's proceed then.
A law that guarantees the full rights in marriage as recognized under Article 31 of the Constitution. I would like to draw your attention to page 8 of our analysis, which gives you the context of what marriage looks like in our country, so that you know what you're actually legislating for. When you look at the tables that are there, it tells you what marriage looks like in our country. So we have people who are living in monogamous marriages, people who are living in polygamous marriages, those who are divorced and separated, those who are widowed, and also those who are never married. And we see that the bulk of Ugandans actually are living in monogamous unions, either legally married or cohabitating. Only 11% live in polygamous situations, 12% are actually divorced, widowed are 13%, and 5.5% are unmarried. We also see the forms of marriage that we have in the second table, where we see that civil marriages are only 1.1%, customary take the bulk at 25%, religious marriages are actually only 9%, and those who are cohabitating are almost 27% of the population. When we look at the context of marriage in Uganda, seeing as almost 83% of all Ugandans are living in or have formed some sort of family forming relationship, and seeing also as our marriage laws are completely outdated, we have the Marriage Act, which was formulated in 1904, the Divorce Act in the same year, the Hindu Marriage and Divorce Act in 1961, the Mohammedan Marriage and Divorce Act in 1906, and also the Customary Marriages Act, which was recently amended in 2000. In the year 2000, it becomes imperative that the marriage laws are urgently updated to suit the current context in order to align with Uganda's ambition of decolonizing. We upload the proposal for the laws that is being made in the current 2024 bill, where we note that there are some things which are much needed and are contained therein. The first is the harmonizing of marriage, of the marital age at 18. We know that many of our acts have differing ages. The customary Marriages Act.
Dear Ugandans, the Electoral Commission is conducting an update exercise of the National Voters Register and registers for special interest groups. The exercise will take place at each parish countrywide for 20 days from 20th January to 10th February 2025, daily from 8 a.m. to 6 p.m., including weekends and public holidays. The update exercise is intended to include particulars of eligible voters that are not on the National Voters Register. During the exercise, the following actions will be done: registration of newly eligible applicants, transfer particulars for voters who wish to transfer to new voting locations, correction of misspelled particulars, inclusion of omitted particulars, voters' claims omitted from the register will be handled. Students who were registered by NERA and have since turned 18 years of age need to present their particulars for updating and assignment to polling stations. Voters are therefore urged to check and confirm their polling stations to avoid any inconveniences on polling day. This message is from the Electoral Commission.
And overtly criminalizes child marriage. We have been struggling with child marriage in this country, and it is something that continues to happen even up to date. Unfortunately, we had no law that overtly criminalizes child marriage. All we had were sexual violence laws like defilement and child-to-child sex, but we never had child marriage. So we welcome this criminalization of child marriage because it expands to capture those who actually perform these weddings and also those who participate in them. We also welcome the prohibition of the demand for the return of bride price, which also aligns with the Mifumi decision, and this is something that we believe is going to lower domestic violence in our country. We also applaud the recognition of presumption of parentage, which we believe is going to add value towards the stability of marriages. We also welcome the provisions on matrimonial property, as people who represent women in court when they are unfortunately at the end of their relationships and are going through the breakage of a family. One of the biggest issues we face is the division of property, and our laws had never set standards. So we are very excited that this act is actually trying to cure this problem, and happy that it's going to set a standard that perhaps will reduce the backlog that we currently have in courts and create more harmonized jurisprudence. We also applaud the recognition of premarital and postmarital agreements. We are now in the era of empowered women. We as women want to protect our property, and we hope that these agreements will help us to do that. And also we applaud the recognition of non-monetary contributions to our family, which recognize unpaid care work, which heavily burdens women in families. We believe that these provisions align very well with Article 31 of our Constitution and advance the rights of women in Uganda. However, we also recognize that there are a few problematic clauses that perhaps would like to be addressed. The first is on the requirement of consent for parents prior to procuring a Christian marriage. What we realize and recognize from our stand is that Article 31(3) of the Constitution individualizes consent. Consent cannot be obtained through other people. It has to be obtained by an individual. By putting the burden of consent away from the person who is getting married and placing it on parents, we feel that this law is going to infantilize the people who are actually entering the marriage. We also know that historically parents have abused consenting to marriage in order to force their children to marry people that they do not want to marry, but also to prevent them from marrying people on tribal grounds or on economic grounds or on some sort of grounds. This, we feel, is moving away from the spirit of the Constitution, which intended to protect individuals who are adults and capable of making independent decisions. The ability, saying that people should consent through their parents, is very paternalistic, and in our view, we suggest that this be actually left out. The other thing that we have a problem with is the requirement for premarital counseling. In our opinion, as people who have also gone through part of this premarital counseling, we believe that this is dangerous because the content of premarital counseling is where most of the patriarchal norms that oppress women are actually advanced. When you go into counseling, you are told to always submit to your husband and also self-sacrifice as a woman. They always emphasize this for women, but downplay male accountability in a marriage. So women are then subjected to a lot of physical abuse. They are subjected to a lot of domestic abuse, but they have no way of getting out of it because the counselor told them something else. So until we get guidelines that actually emphasize the autonomy of women when it comes to marriage counseling, we believe that counseling may be good under some circumstances if a couple is having problems. Our challenge is around what type of counseling is going to be given. And if it's one that devalues women and places men on a pedestal, or if it is one that grants women their dignity and amplifies their rights. And unfortunately, in the marriage bill, it is not clear what type of counseling we are actually emphasizing. What we know is that counseling is usually done on religious or moral grounds, and some of these religious connotations and cultural norms often view women as less than men, and we feel that this counseling may perpetuate this position. Another thing that we disagree with is the clause 6A that handles and makes civil marriages potentially polygamous. So when it comes to polygamy, there are things that we feel have been sneaked in. The first is sneaking polygamy into civil marriages. Historically in Uganda, civil marriages have never been polygamous. They've always been monogamous. Uganda has signed on to the Convention on the Elimination of All Forms of Discrimination Against Women. We've also signed on to the Maputo Protocol, and both these conventions advance monogamy as the ideal form of marriage because monogamy advances equality and advances women's rights, which cannot be realized in polygamy. So by sneaking polygamy into civil marriages, we feel that Uganda is creating a standard where the standard for marriages in Uganda is going to be polygamy, and women will have no choice but to always endure polygamous relationships. And yet we are moving towards a human rights, value-based system. So we feel that this is going to violate women's rights, and this is something that shouldn't be allowed. Also, when we read this marriage bill, we realize that polygamy and its interpretation is actually only polygyny. This law doesn't allow for polyandry, which is advancing unequal rights for men and women. What I mean by this is that it only allows men to marry multiple spouses, but it doesn't allow women to marry multiple spouses. The spirit of Article 31 is that marriage should be equal. Equal rights within marriage, during marriage, and upon dissolution. So if men are allowed the particular entitlement in marriage, we believe that even women should be allowed to equally marry more than one spouse.
You see, sorry to interrupt. You see those mamas you're getting, the Honorable Fox Odoye arrived.
Yes.
And he has been a very strong advocate of.
Dear Ugandans, the Electoral Commission is conducting an update exercise of the National Voters Register and registers for special interest groups. The exercise will take place at each parish countrywide for 20 days from 20th January to 10th February 2025, daily from 8 a.m. to 6 p.m., including weekends and public holidays. The update exercise is intended to include particulars of eligible voters that are not on the National Voters Register. During the exercise, the following actions will be done: registration of newly eligible applicants, transfer particulars for voters who wish to transfer to new voting locations, correction of misspelled particulars, inclusion of omitted particulars, voters' claims omitted from the register will be handled. Students who were registered by NERA and have since turned 18 years of age need to present their particulars for updating and assignment to polling stations. Voters are therefore urged to check and confirm their polling stations to avoid any inconveniences on polling day. This message is from the Electoral Commission.
It's our belief as women's rights organizations that this country should advance monogamy as the standard of marriage in order to advance equality in marriages. But these particular provisions on polygamy are taking us a step backward. The other thing that we wanted to touch upon that we actually don't agree with is the criminalization of cohabitation. As we have seen in the context of marriage, almost 27% of all couples are cohabiting. They are not living in legally recognized unions. We cannot shut our eyes to this context in our country. Cohabiting is a social issue. It's not a legal issue, and it's not an issue that is going to be resolved by punitive measures. This is something that needs to be resolved socially. We also note that many couples fail to get married, largely because of lack of funds. Marriage is very expensive. To hold a decent wedding in this country, you need at least 10 million shillings and above, just in order to gather your family. We also cannot neglect the fact that many families require bride price, which means you need to take cows. So if people can't afford to get married, why are we punishing them? By taking them to jail. This particular provision in our eyes is something that is blind to the context of Uganda and also the socio-economic realities of the people. And we fear that we may end up with almost half the population in jail if this provision is to be passed as is. The last one is around sharing of debt, which doesn't recognize the power dynamics within families. That is actually in clause 51 and 55, where they say that you can share debt if it is accumulated on matrimonial property. This particular provision assumes that spouses disclose to each other their financial liabilities, and also that women often understand the documents that their husbands sign on or present to them to sign on, especially when the women are mostly not the providers in the family. They go with what their husbands say. So this particular provision becomes blind to the power dynamics that lie within the families, where the man is the head and the woman is always perceived as the neck. What your husband says, you're supposed to do. If he says sign here, you sign here. But sometimes many women will not realize that they are accruing liabilities towards themselves. And we fear that this may turn into financial abuse ultimately if it doesn't consider the power dynamics that are within families. So these are the general recommendations that we make, and the general recommendations are on page 22 before we go to the specific ones, clause per clause. The first one is to consider removing the polygamous clause from civil marriage provisions. We know that historically in this country, customary marriages have been considered polygamous, and also Mohammedan marriages have been considered polygamous. This is something that we may not change today, but what we can change is to make sure that those that have been historically monogamous remain as monogamous, even as we push towards monogamous marriages. Additionally, we would like for this bill to provide for circumstances under which a person can take on a second wife, and these were proposed under the Domestic Relations Bill. And some of them include that a polygamous marriage should only be permitted where there is consent from the previous wives, proof of one's ability to cater for more than one spouse, and also the provision of separate residences for each wife. This is what we are calling for. Furthermore, we want this honorable committee to actually cross-check the definition of polygamy and align it to ensure that if men are allowed to marry more than one spouse, even women are equally allowed the same rights. We also call upon this honorable committee to make premarital counseling optional rather than as a requisite, because some people don't subscribe to particular cultures, they don't subscribe to particular religions, so it shouldn't be mandated that everyone should do premarital counseling. We also require this committee to do away with the provision requiring parental consent, as this violates Article 31(3) of the Constitution, and also consider doing away with provisions on sharing of debts. Specifically from page 24, you can see some of our specific recommendations and how we would like the bill to actually look like. I'll just skim through this because we have already justified what we wanted in the first place. The first one is around clause 2, which talks about the irretrievable breakdown of marriage. We wanted a more expanded definition, which we have proposed. We also want to adopt a proper definition for polygamy. Instead of saying a marriage in which a man is married to more than one wife, it's where an individual is married to more than one spouse. Clause 4.1, which is on page 25, we request this honorable committee to make civil marriages monogamous. Currently, only Christian marriages are guaranteed as monogamous unions under this bill, which in our opinion is a travesty, and it's something that needs to be immediately remedied. Polygamy should not be the standard in Uganda. On page 26, we propose changes to clause 5B, where we propose to eliminate the consent of parents, as this violates Article 31(3) as already stated. In the alternative, we propose that instead of using the word shall, Christian marriage shall be with the consent of the parents, we instead use the word may, so that some of these institutions that are carrying out the marriages have the option not to procure the marriages, especially where they feel that the consent of the parents is being arbitrarily denied. Under clause 15 on page 27, we propose to delete the requirement for premarital counseling. In the alternative, we propose that it be made optional by changing the use of the word shall to the use may, so that again it remains optional. On clause 39 on page 28, we are proposing the deletion of which allows for the conversion of a polygamous marriage, rather of a monogamous marriage into a polygamous marriage. We have made a case for not allowing polygamy to become the standard of marriage in Uganda, and this means that we cannot allow for the conversion of a monogamous marriage into a polygamous marriage. We are also proposing that if this be left in terms of converting marriages, we adopt the provisions that are under the Marriage Act 2014 of the Republic of Kenya, which allow for the conversion of a polygamous marriage into a monogamous marriage, but reject it for a monogamous marriage into a polygamous marriage. It is all stated there. And on page 29, we propose changes to clause 40, where they talk about voiding a marriage on the grounds of health conditions. Health conditions should not be the prerequisite to void a marriage. There is a difference between voidable marriages and void marriages. Void marriages are those that from the start are illegal. They are completely illegal. You cannot enforce them in any way. But a voidable marriage means that a party can opt out on a particular ground. So for us, we are saying that the inability to have sex shouldn't be the grounds to void a marriage. It should be made voidable, because sometimes people don't have sex. Under clause 43(2), we are proposing, this is on the use of names. This right is only given to women, and we feel, as Honorable Chairperson, you stated, that men are very vulnerable in this society, so they need equal rights under this particular law. If a man wants to use his wife's name, they should be allowed to use the wife's name. But unfortunately, under this bill, they are not allowed to use their wife's name, which is a travesty in our opinion. We propose that clause 43 be amended to allow men to also use their wife's name in case they want to, in order to align with the spirit of Article 31, which allows for equal rights within marriage and upon its dissolution. We are also proposing changes to clause 51, where we are asking for the elimination of debt sharing on property that becomes matrimonial property. We had already explained our reasons and how marriage is construed in the country and the power dynamics that lie, especially eliminated. We are also proposing a change to clause 8, individual they are actually not married to. And it's our belief that this has no bearing on our context. These are not really cases that we have seen or cases that have been criminalized. It's just a colonial concept. And also with the registration of marriages and the opening of the marriage register, it becomes very easy to verify who is married to who. So this offense therefore becomes useless on our law books. And also we are proposing the deletion of clause 89, which criminalizes cohabitation using other languages for reasons that I have already explained. Honorable members of the committee, this is our analysis. Our biggest prayer is that what we are looking for as women of Uganda is a law that is not going to oppress women in marriages. Thank you.
Thank you, Immaculate, for your for your able consensus by all the people represented here. You had your hand up? Please.
It was developed with everybody here, but I think it would also be great if we got just a few minutes for any other members that may have proposals, recommendations, perhaps before we can hear from the members of parliament on thoughts about our recommendations.
Okay, let's have 2, 3 so that we pick ideas. You don't need to emphasize what has already been presented. Would welcome something new from what we already have. Any?
Domestic Violence Act Coalition that is here in your presence today. I just wanted to add 2 points. One is on clause 83 that touches a lot of the work that we do at FIDA, that is custody, maintenance, children's rights. It speaks about maintenance to cease on remarriage of the woman, which makes a lot of sense, and I must share that these are things that we see every day, that usually when a couple separates and the woman remarries, usually it becomes, the relationship, the mediations become volatile. It's usually very difficult to reach a consensus. This particular clause mentions that maintenance of the spouse, who is the woman, the responsibility of raising children still continues to be for both parents, whether they are together or not. So we've had cases where our mediation agreements start not to get implemented, usually, especially when the man has ceased having any relationship with the mother. So our proposal is that clause 83 clearly states that maintenance of the child will not cease for both parents, whether each one of them remarries. That was one of the issues. Then the second one, let me just go to it. I think it's clause 41 on voidable marriages. There's a 6-month timeline for consummation of marriage. And for us, we believe it might be unreasonable because 6 months is such a short time. For certain health issues, for example, that the clause speaks about, they may not show within 6 months, or people may not be okay. So we believe the 6 months limit is very short, because we believe when people marry, they keep saying forever one day, we'll be together forever. For 6 months, for you to believe that that is not going to work because there's not been consummation of that particular marriage is also something that I wanted to just add on what Rose has presented. That's all, ladies and gentlemen.
Dear Ugandans, the Electoral Commission is conducting an update exercise of the National Voters Register and registers for special interest groups. The exercise will take place at each parish countrywide for 20 days from 20th January to 10th February 2025, daily from 8 a.m. to 6 p.m., including weekends and public holidays. The update exercise is intended to include particulars of eligible voters that are not on the National Voters Register. During the exercise, the following actions will be done: registration of newly eligible applicants, transfer particulars for voters who wish to transfer to new voting locations, correction of misspelled particulars, inclusion of omitted particulars, voters' claims omitted from the register will be handled. Students who were registered by NERA and have since turned 18 years of age need to present their particulars for updating and assignment to polling stations. Voters are therefore urged to check and confirm their polling stations to avoid any inconveniences on polling day. This message is from the Electoral Commission.